Tune in to Talking Law with Attorney Daryl O'Neill and the special guest host, Attorney Jerome Payne. Live TV talk on your digital device, on Roku, Fire TV, and Apple TV. Download the SVP TV app right now. Check us out every Tuesday on Comcast Cable, Channel 17.
Welcome to Talking Law with Daryl O'Neill. I'm your host. I got my main man with me, Jerome.
What's up, Daryl?
Man, another day in the neighborhood.
Absolutely. It's a cold day in the neighborhood.
Man.
What's up?
I don't, man, what the world? I mean, what, last week, man, it was, you had to take all your clothes off, man, it's so hot. And now you need to put that coat back on.
You better get it back out of the closet.
Yeah. So, we need to say welcome to Facebook.
Yes.
And welcome to YouTube, because I know, I think they're live. So we got YouTube and Facebook live. Again, if you have Roku, Fire Stick, Apple TV, or the SVP TV app,
yes,
you can actually watch online live also.
And we can answer your questions in real time, too.
Man,
yeah.
See, that's the thing that people, man, you know, when we used to do the show, when the show was live,
right,
man, we couldn't get through a show without asking 10, 20 questions, man.
That's for sure there.
Yeah, so.
Why anybody would not take advantage of 52 years worth of legal experience,
yeah,
and not answer their questions, it just doesn't add up to me.
Yeah, you know, everything's different, man. You know how that is.
That's true.
So we also need to say welcome to Little Rock, normal viewing audience in Little Rock. Welcome to West Memphis. Welcome to Shelby County, Memphis. Welcome to Mississippi. And Mom, welcome to the great state of Missouri.
Always.
Yeah. So we need to be talking about landlord-tenant.
There, that's always an interesting topic, particularly with African Americans. You know, the rate of home ownership for African Americans is probably lower now today than it was 10 years ago. And so most of our people are out looking for some place to lease, rent to own, or something like that. And sometimes they have some difficult problems doing it. And maybe if we would break down the tenets for the relationship, it's all spelled out in the Uniform Code of...
Yeah, the landlord, the URL, so Uniform Residential Landlord Tenant Act. Yeah.
Yes, it's all spelled out what the requirements are for each of the parties. And that makes it pretty easy for us to go over it and to protect both the landlord and the tenant.
Yeah, in the larger counties, and I think it's 200,000 or more,
yes,
gets the benefit of what they call the Uniform Residential Landlord Tenant Act. And this is a statute, this is a code.
Right.
And what the legislators decided to do is to codify what is expected from the landlord and what is expected from the tenant.
Absolutely.
And if either one of those people fails to abide by their responsibilities, these are the consequences.
And that's called a breach.
That's a breach.
Yeah, right.
That's a breach. So let's talk about let's take this from the beginning.
Okay.
So the Landlord-Tenant Act, covers landlords and it covers tenants.
Right.
The Landlord-Tenant Act, Uniform Residential Landlord-Tenant Act. But why do anybody care about that?
Oh.
I mean, if I have a contract and I can write a contract and myself and whomever can agree to the terms in the contract, why do we need the Uniform Residential Landlord Tenant Act?
That's an interesting question. It's like anything else. Why do we need rules of the road? Why do we need to have stop signs? Why do we need to have red lights? So we can control people's conduct. Okay. Because, and then that way there's no issue about whether or not something is a violation or not, because it's codified. And so we just go to the section and we read over it and we determine that someone has breached. So first of all, and you probably could do a contract between you and a tenant that does not follow the Landlord-Tenant Act. Could you not do that?
I think you potentially could. But I think the statute would override any violations in the contract. Like, for instance,
That's interesting.
you know, when I used to first write these leases for people, and what would happen is they would pull one of these leases offline.
Oh, yeah.
A lot of people would pull a lease offline, and then they would take that online lease and then try to use it. The problem with it is Tennessee has some real particular rules that you have to abide by. And some of those online leases don't cover that. For instance, the Uniform Residential Landlord-Tenant Act, which you must comply with, states that the landlord, if the landlord takes a deposit from you, the landlord has to state in the contract that they took this deposit and where that deposit is, what bank is that. Now, they don't have to give you the banking number, the tracking number, the routing number, and that, but they actually have to say what bank is that. And most people don't know that.
And should it gain some interest or something, does that go back to the tenant?
I don't
the
remember.
landlord is able to keep that?
Yeah, I don't remember how that. I don't remember whether this. That's a little more particular than I.
Okay.
Because what ends up happening is, because it's not about the interest.
It's about the deposit being somewhere where it can be accessed should it be needed.
Exactly.
Okay.
Because it's not a document, or it's not money to allow the landlord to take if you don't pay your rent.
Okay.
That's not what it's for.
Okay.
It's for a security deposit because of damages that you caused on the property.
Okay. So what's the penalty should landlord X not do it?
It doesn't give a penalty.
And see, and so you know what? That sounds like a useless, isn't it?
Well,
that's a useless provision if there is no enforcement action behind it.
I think the argument could be that there's an argument you could void the entire contract.
Well, it's probably something cumulative. You probably have to pack it with something else, wouldn't you? And possibly get a penalty in. In other words, you can show a continuing violation even from the inception, possibly. If they didn't comply.
Well, there is a provision in most of these contracts that say a waiver.
Yeah. If one term does not void the entire.
It doesn't void the entire. You know.
That's right.
You know, that's a separation clause that a lot of lawyers put in there. I mean, decent lawyers put that in there. Some lawyers don't put it in there, or some people don't put it in there, and they don't realize the ramification to that. Because you can make a mistake in a contract on accident. I mean, you can, you know, I just got one invalidated.
Sure.
You know, and this was done by lawyers.
I mean, the entire
contract was invalidated.
Wow.
Because it did not have a separation clause language in
I
there.
can't understand how anybody would.
And then the document internally conflict with each other. So if it conflicts with each other, then you got to take away from the offending language. That's what it is.
Okay.
But which part of that offending language do you get to take away? Because if this is offensive to this, which one of those do you get to take away?
Both provisions?
I think you take both of them out.
I think so too.
And there's an argument if you take both of them out, that changed the entire meaning of the contract.
I think that's absolutely correct.
You know, and that's, you know.
But also too, contracts are construed against the drafter.
Against the drafter.
So you could possibly turn it in your favor as a defense, the person who is being. You can turn it around against them.
That's what I do.
That's what you do.
And that's what because, you know, Jerome, what's happening here is the novice doesn't know anything about contract.
Right. That's right.
The novice tenant doesn't know all the landmines or pitfalls in the document that they're signing.
That's right.
They're not relying on anybody. They're reading.
Well, they're relying on the landlord.
To be honest.
Because the landlord has more power than the tenant, so to speak.
Right.
Because he had every right to draft the lease the way that they wanted to draft it. And so you're right. The novice person has no idea.
Yeah.
He or she just wants a place to lay their head at night.
Yeah, and so one of the things that I see so often, and it turns out becoming the downfall of not only of the landlords or the draft of the contract. I'm sorry, it doesn't a lot of times just hurt the person who signed the contract. A lot of times they put language in there that actually hurts them. For instance, a lot of contracts these days have an arbitration provision.
Right.
Okay, then that means you can't go down to Shelby County Circuit Court or Shelby County Chancery Court or General Sessions. And arbitration is substantially more expensive on the front end than going down to General Sessions.
So if it's an arbitration clause in there and you both agree to litigate it in General Sessions, because General Sessions has the absolute jurisdiction over landlord-tenant matters,
Yeah.
can you not override the arbitration clause?
Well, check this out. If I'm a tenant that's being thrown out, why would I do that?
Why would you want to do that?
Why would I do that? Yeah, if I'm a tenant.
Because I don't know any better.
Yeah, if I'm a tenant and I'm getting ready to be put out. Right? And the only way I can be put out is through an arbitration process. Why would I agree to that?
That's right. Because
it's going to take longer than 2 weeks.
That's
if
right.
I put it in general session, basically you get a continuance automatic.
That's right.
Then the court has to set it for a hearing within 10 days.
That's right.
So you get your first setting, and unfortunately, that may take, so in today's world, that may take 2 or 3 months.
That's for sure.
So a tenant is living in your property for 2, 3, 4 months and not paying rent, and ain't nothing you can do about it.
That's true.
Because that's how the rule has changed.
That's how the rule has changed.
Because court's taking forever to get the things.
That's right.
No disrespect for the court. It's just that the process has done that. So then, once you get a hearing date, they get to say, Your Honor, I need a continuance.
And that's one of the local rules.
That's a rule.
So either side, for any reason,
I don't need
can request a
I ain't got to explain it.
That's
I don't
right.
need no excuse.
That's exactly right.
All I got to do is just say it.
That's right.
And then in 10 days.
That's right.
And then you come back in 10 days. And then normally you come back in 10 days. A lot of times what happens, the tenant don't even show up. Because they just needed that time to,
Well, that's your trial date.
That's your trial date.
When you come back to
when you come back to your
10
trial.
days. That's right.
And so let me ask this question, Jerome. And here's what happens. I'm going to put you out, right? Because you ain't paying rent.
Right. It's alleged.
That's okay. It's alleged.
It's alleged.
Hold on.
Because
you say it's alleged. You know good well you ain't been paying rent.
I don't know. I don't know. All I know is I put it in the mail.
Yeah.
I dropped it in the drop box where I normally drop it at, and I have a receipt showing that I have sent it.
Now you done hit pay dirt, man.
Right.
You don't hit gold right now.
Right, exactly.
Because what you have to do, and here's what people say: well, I paid. Well, where your receipt?
That won't do it.
I don't have it. I gave it to them. The law requires, the onus is on the tenant to prove they paid.
Right, and I like that, Dara, too, because I'm a fan of tug of war, because when you show up, you both on equal footing, and when the landlord gets up on the stand and he testifies, that users whatever, and he say he owed me this amount of money, and then the tenant, because he's pulled over this way now, and the tenant has to come back by showing some valid reasons why they haven't paid or did pay, and that's receipts.
Right.
And then so now you're back again, and then we start talking about credibility, right? So where we go from credibility?
Well, let's back up for a minute.
Okay.
So, here's where people go awry. Rent is due on most contracts on the first of the month.
That's right.
They'll give you what they call a 5-day grace period.
Right.
But you're late.
It's still late, though.
It's still late. And you're in violation.
Okay.
But there's a clause that I have in the contract say if I choose to waive that receipt period, I'm okay. And any waiver doesn't mean it's a consistent waiver.
That's interesting. That's interesting.
Because rent is due on the 1st, and I give you a 5-day grace period.
But it falls on the weekend.
Then I always say that
The following work day.
following work day. That's what the law kind of says.
That's right. Or I mailed it and I got a 3-day.
No,
You don't get the 3-day
no. You better mail it early.
Is that right?
Oh no. There's no mail grace period.
Okay.
So here's what a lot of landlords do. They say that the rent is due on the 1st.
Okay.
But it's not late
Until the 5th.
until the 5th or the 15th.
Okay.
But it was due on the 1st.
Right.
So you have breached the terms of the contract by not paying on the 1st.
Okay. Now, in reality, what tenant living from paycheck to paycheck can pay on the 1st of the month?
That's a nice argument, Jerome. Here's the problem.
Because I don't get paid until Friday.
That ain't my problem. Because see, what ended up happening is you knew that when you signed the lease.
Right, and the landlord has been doing it over and over again.
Yeah.
He and I had talked about it. Now, all of a sudden, he wants to just change the rules.
Yeah.
Because he's waived the right to require me to pay on the 1st every single time, right? Because you've done it several times.
Well, that's an argument that people try to make.
Right.
And the reason
It's
why
a successful argument.
it can be, depending
Okay.
on the judge. It can be a successful, because they talk about, course of dealings.
That's right.
I mean, there is some case law about course of dealings.
Right.
But here's where a good landlord or a good lawyer or a good drafter has protected themselves. A good drafter will say in that document that any waiver of any terms doesn't mean I've waived it forever.
Oh, that's true. But you got to put me on notice that you no longer are going to receive the rent late.
But then the second thing is,
Okay.
just because I voluntarily do it,
Right.
what the contract says, if it ain't in writing, it can't be changed.
You know what? And that's right. It said no oral
Bingo.
changes. Yeah.
So
I can
just
see that,
because I allowed you to do
got
it,
you.
don't mean I've agreed to
I
it.
got you.
I just chose not to take action.
And you know the thing about it too, Daryl, is that's what makes a good legal issue. And some judges may buy it, other judges may not. It just depends on how well it's presented. And so the relationship, I've been living in the place for 2 years, 3 years, 4 years.
Right.
All right. And so the pandemic comes along. That's how we're going to get there.
Okay, the
Pandemic comes along. The government is offering funds for tenants who are delinquent in their rent.
And they still offer those funds.
Yeah, due to the fact that you no longer are getting as many hours as you used to get. And so I just need the landlord to be patient enough. I've made my application. I've been told that I'm going to receive the funds. And so, but the landlord says no. Where do you go from there?
You out.
I think that the judges would require the landlord to wait.
No. The statute doesn't require that. Yeah.
See, this is no longer statute. This is COVID.
This is human.
Relief period.
Yeah, this is being human.
That's right. That's exactly right. And so the judge is probably going to require that landlord to at least investigate. And in fact, they're required to even tell tenants that the money is available, aren't they?
Yeah, but they have to say whether or not they subscribe to that program or not.
That's true.
And if they say, I don't do that program, the court can't order you to be a part of that program.
Court.
Let me clean it up.
Yeah.
Because we can't never say what the court can and cannot do.
That's right. That's right.
But I think it's a strong appealable issue, though, if the court in fact did order that.
I mean, but what's the damage? You got your money. Tenants stayed a few extra days without paying. I mean, so where's your damages? No, we always talk about damages.
We do. We do.
So how were you affected by the fact that you had to wait until CDC cut the check?
Well, and that assumes that the check covers that period and then forward.
Well, you don't get all of the money. All the money anyway, do you? You don't get late charges. You don't get attorney fees. You don't get the full amount.
Well, most of those guys that do that, even the ones that accept the program, they take judgments.
They're going to get a judgment?
They go ahead and get a judgment.
Okay. Okay.
They go ahead and get a judgment. Some of them will let you stay, but they get the judgment.
But then what does that do to the person who needs to find a place after they leave this landlord?
Oh, it hoses them up. It puts them at a disadvantage.
That's the worst thing in the world, is to come into a new place and try to get a lease with a company, and you got a FED already on your record. More than likely, you're going to get turned down.
It is. Look, the law is not friendly to disaster. That makes sense?
Absolutely makes sense, but I'm surprised you said it. I'm surprised you admit that.
Well, and here's the only reason why I can say that, Jerome.
Okay.
You know, we got the medical malpractice statute, we got the workers' compensation statute, and all those are tragic situations that happen to people.
Right.
We got statute of limitations that end due to no fault of people. They can't find people, and your case dies.
That's true.
So the law, you are catastrophically injured.
That's true, yeah.
And if you miss the statute by one day, catastrophic or not, your case is dead.
That's true.
So the law doesn't take in consideration your catastrophe.
And so that's why we have law and equity, right?
Yeah.
Even equity would save you, maybe.
No.
It wouldn't save you in that situation. It depends on what kind of case it is.
Yeah, here's how you save yourself in a statute of limitations case. And what defense firms have a tendency of doing is they put, when they file their affirmative defenses,
right,
they say in their affirmative defense that you filed your claim outside the statute of limitations. Okay? That's what they'll say in their affirmative defense.
Okay.
If they say that, then there's an argument, if you're outside the statute of limitations, they have saved their argument to contest the statute of limitations.
I see.
If they don't address the statute of limitations in an affirmative defense, it's waived. What normally
you can waive the statute of limitations?
The statute of limitations can be waived.
Oh my goodness, I didn't realize
because
that.
It's an affirmative defense.
Okay.
It's required to be pled.
Right.
It's like latches, unclean hands. All those are affirmative defenses that have to be pled.
I got you.
Res judicata, all that's got to be pled. And if you fail to plead it, you lose. You waive it.
Okay.
Now obviously you can come back in and file an amended complaint or amended answer, because just like the court freely gives leave to file an amended complaint, it freely gives leave to file an amended answer.
Okay.
But the problem with that, Jerome, is
you don't want to be in that position.
You don't
to be bleeding and waking up in the middle of the night looking for mercy from the court. That situation. You do not want to be there.
You don't want to be there.
That's right.
That's not where you want to be.
That's exactly right.
I think I was telling you about a case I listened to oral arguments where the lawyer failed to get the service within a period of time.
That's right.
And the trial court dismissed her case. The Court of Appeals ruled in her favor.
Oh, they came back and ruled in her favor?
Yeah, and let me tell you the reason why. Originally when I was listening to an argument, I was like, whatever your argument is not good.
Right.
Because that's not where you need to be. The real argument in my mind, and I get my nerd on because I listen to these arguments and read these motions that come down every day, man, like I ain't got nothing better to do. Just anyway.
You're a nerd, huh?
Yeah, get my black nerd on, man.
It's popcorn to listen to the argument, huh?
Go ahead, Judge, ask that question. That's a good question, Jan.
Right.
Like I'm in the argument, right?
I got you.
But the real issue that the judge really didn't do, the judge did a bad job on, in my opinion, is the reason why the lady's statute or the summons rule didn't apply, Rule 4 didn't apply to her, is because the statute had never ran. It was a minor.
Oh.
The statute doesn't even start to run.
Yeah, we talked about that
to
before.
to the age of majority plus
right.
one.
That's right.
You can't make me file it with it. And what the court, what they did, the defense said, Your Honor, she's got, if the parents know about it, they got to file it. And the judge bought that.
Mm-hmm. And
there's a case out there. There's some cases out there that say that.
Right.
And with the Court of Appeals, man, it's Armstrong, and it was. I think that the panel was Armstrong, Stafford, and maybe Golden.
Golden, yeah.
Sharp, man, Sharp. They ain't gonna let you get away with. I mean, they were on it, man. They, if you are wrong, man, they gonna affirm. Mm-hmm. But I mean, if you right, they gonna reverse, and don't have no problems with reversing. So
right.
So the thing is, it really is all about, not screwing that up.
Right, exactly.
But if you got a lawyer that's decent and they file that as an affirmative defense, what I usually do is I file a motion to strike that affirmative defense. And Muzz be like, man, you the only lawyer in the world to be fighting to strike affirmative defenses, because don't nobody want to plead facts.
Right.
The law requires, it's just like, an affirmative defense is just like a lawsuit. You got to plead your facts.
With specificity.
No, it's short and sweet. It's notice.
Yeah. Okay.
But you got to put a fact in there.
You got to put some kind of fact.
You can't say,
not just say statute of limitations.
Yes, statute of limitations.
Right, I got you.
There was already, fails to state a claim. What claim?
Right.
So that's the thing.
I got you.
But what happens in these landlord-tenant matters is the court. These people, you're right, Jerome. They're in their worst scenario.
No question.
They're in a real dire situation. But the court don't get into that. The courts. Now, I tell you what court will get into that, which is Chancery Court.
Well, yeah, of course.
Because it's a court of equity.
Court of equity.
Yeah,
right.
so it can do that. Now, there are some judges that say, yes, court of equity, but it follows the law. That's true, but that's why it's equity.
That's right.
If this is the right thing to do, the Chancery Court has the ability to say, this is the right thing to do.
That's right. That's right.
So, how do you look at that?
Well, I think that that both landlord and tenant should have a meeting of the minds going in.
All right.
And then when there's a default, then make sure that each one of them covers themselves by having some legal advice.
Yeah.
And so that's the best way to avoid all of the issues that we see every single day. Time and time again, Daryl.
And we make this joke before numerous times. There's only one lawyer in the world I hate. I can't stand that mug.
And that's Facebook?
No, that's Google.
Google.
Google, the worst lawyer in the world. Because, everybody believes you can hit Google and learn the law all like that.
In what, 30 minutes?
No, not 30 minutes. 3 minutes, whatever longer time
it take to print
the article out, to read the article, and then they'll have a whole lawsuit filed based on what Google said.
Right.
And you're like, they don't follow Tennessee law, right?
That's right.
So, yeah, get some advice, man.
That's exactly right.
I mean, LegalZoom works if you have some background knowledge.
That's exactly right. Yeah.
Google works if you have some background knowledge. Because I've used Google before.
But it will not stand on its own.
Man, you can't do it on its own. Google, what Google has done for me is sometimes it gives me a point of reference.
Right, exactly. Yeah.
And that's it. All right, man. I know we
it's a good topic.
It's a good topic.
It's a relevant topic.
It's a real relevant topic. Look, again, we extend our arms to you to answer, ask whatever questions you have.
No question about it.
Call in. I mean, all those things. Put something in the chat room on Facebook or YouTube, and we'll respond to any of that stuff. As usual, we appreciate you watching the show. Thanks, and we'll see you back next week. We won't see you next week.
Oh, that's right.
Next week is Good Friday. See you after Good Friday.
All right. He's risen.
All right.
Tune in to Talking Law with attorney Daryl O'Neill and the special guest host, attorney Jerome Payne. Live TV Talk.